I want you to picture a scenario. It feels like something, ripped straight out of a spy thriller, but it is a genuine legal nightmare. Imagine a crime is committed inside a foreign embassy right here in New Delhi. I'm talking about something serious. The police rush to the scene, sirens blazing, adrenaline pumping, but they hit the brakes at the gate. They literally cannot cross the threshold. They just have to stand there.
It's a frustrating image, isn't it? The law stopping at a literal gate.
Exactly. Or take a different scene. A satellite launched by Country A malfunctions, spins out of orbit, and crashes into a farmhouse in Country B. Who pays for the roof? Who's liable? Is it the company that built it, the country that launched it, or is the farmer just out of luck?
It sounds like chaos. It sounds like, the Wild West. But the fascinating thing is, 9 times out of 10, the roof gets paid for. And the diplomat eventually faces justice, or at least leaves the country. It's not magic. It's the result of this massive invisible operating system.
And that is exactly what we are decoding today. Welcome to the deep dive. We aren't just reading a textbook on public international law. We are unpacking the source code that governs how nations interact, from the soil under our feet to the bottom of the ocean, and even surprisingly, to the surface of the moon. We're looking at the rules of the road for planet Earth, with a specific focus on how India plays the game.
It really is an operating system. We take it for granted that mail arrives across borders, that flight paths are coordinated so planes don't collide.
That ambassadors don't get taken hostage.
Right. But none of that is the default state of humanity. It's a constructed reality.
But here's the snag that always trips me up. In a domestic system, like here in the city, if I break the law, the police come. There's a hierarchy. In the international system, there is no world police. There's no global sheriff writing tickets. So before we get into the weeds of space treaties and sea laws, why does any of this work? Why don't strong countries just ignore the rules entirely?
That is the fundamental tension. And to understand it, we have to look at the source code, written back in the 17th century by a Dutch jurist named Hugo Grotius. In the literature, he's often called the father of international law.
This is the De Jure Belli Ac Pacis on the law of war and peace.
Correct. Published in 1625. Now, you have to understand the context. Before Grotius, kings followed rules, mostly because of, religious dogma. God ordained the king, so the king followed God's law. Grotius did something radical for his time. He secularized it. He argued that law should exist even if God did not exist.
Which, in the 1600s, sounds like a good way to get yourself in a lot of trouble.
It was risky, but he moved international law from theology to rational state practice. This created what we call the Grotian tradition. It's a middle path. It's not pure realism where might makes right and the strong do whatever they want, but it's not pure idealism either. It's the pragmatic idea that states are like people. They form a society, and a society needs rules to function, or else commerce, safety, and communication collapse.
So it's less about being good and more about being functional.
Precisely.
Okay, let's unpack this. If we're a society of states, the first logical question is, who gets to be a member? What actually defines a state? Because I've always wondered, can I just declare my apartment a sovereign nation, the United Republic of the living room?
You can certainly try. You can print a flag and write an anthem. But legally, you will fail the Montevideo criteria.
The Montevideo Convention of 1933. It sounds like a spy novel title, but it's actually a recipe. It lists the 4 ingredients you need to bake a country. Let's run through them. First, a permanent population.
Right. You need people.
Check, me and the cat. Second, a defined territory.
A living room. No.
Third, an effective government.
I'll give you the benefit of the doubt on that one.
Thank you. But the fourth one. This is the hurdle, isn't it? The capacity to enter into relations with other states.
That is the kicker. No sovereign nation is signing a trade treaty with your living room. You don't have the capacity to act on the international stage. This brings us to the tricky concept of recognition. Does a state exist because it says it does, or because other people say it does?
This is the battle between the constitutive and declaratory theories. The constitutive theory, which I think the philosopher Hegel liked, says that recognition creates the state. You don't exist until the club lets you in.
Exactly. It's the exclusive club model. But India, along with most modern democracies, leans toward the declaratory theory.
Which is the facts on the ground model.
Yes. The declaratory theory argues that statehood is a fact. If you meet the Montevideo criteria, population, territory, government capacity, you are a state, regardless of whether anyone likes you. Recognition is just a formal acknowledgement of that existing fact.
However, looking at India's diplomatic history, we see that recognition is also a massive political tool. It's not just a checkbox. The sources highlight the distinction between de facto and de jure recognition.
Think of it as the difference between, say, dating and marriage. De facto recognition is provisional. It's a wait-and-see approach. You might exchange trade representatives, allow some travel, but you don't exchange ambassadors. You aren't fully committed.
And the classic example here is Israel.
Precisely. This is a great case study in Indian diplomacy. India recognized Israel de facto in 1950. We acknowledged they existed as a state. But, due to various political factors, we didn't establish full diplomatic tiers de jure recognition until 1992.
That's a 40-year engagement period.
It was a long engagement. But once you grant de jure recognition, it's the full marriage. It's permanent, irrevocable, usually, and typically validates everything retroactively.
There's another side to this coin regarding territory, the Stimson Doctrine. This feels particularly relevant for India given our history with border disputes.
The Stimson Doctrine is crucial. It essentially says, we will not recognize any situation, treaty, or agreement brought about by means contrary to international covenants. In plain English, if you acquire territory by illegal force or invasion, India won't recognize it as yours. Conquest is off the table.
So we've defined the state. Now let's talk about the people inside it, the citizens. There's a fascinating case in the Stat called the Nottebohm case. It really hammers home that citizenship isn't just a piece of paper you buy at a kiosk.
Friedrich Nottebohm, this is a classic.
Yeah.
He was a German national living in Guatemala during World War II. Obviously, being German in the Americas during the war was inconvenient. He didn't want to be treated as an enemy alien.
So he gets creative.
He goes to Liechtenstein, where his brother lived, and essentially buys his citizenship. He pays the fees, waivers are signed, and he gets the passport. He thinks he's safe, he's neutral now.
But when he tried to use that passport to get protection against Guatemala seizing his property, the International Court of Justice said, not so fast.
They applied what is now famous as the genuine link test. The court said a passport isn't enough. You need a real social connection to the country. Things like residence, family, participation in public life, all for that country to have the right to protect you internationally. You can't just shop for a paper nationality to avoid the consequences of your original one.
Which is a terrifying thought if you don't have any nationality. Statelessness. The sources call it being a legal ghost.
It's a tragic status. If you are stateless, you technically don't exist in the international framework. You have no government to advocate for you, no one to issue a passport.
But this is where domestic law steps in. In India, under the Citizenship Act of 1955 and subsequent Supreme Court rulings, there's a safety net. The court has held that Article 21 of the Constitution, the right to life, applies to persons, not just citizens.
That is a vital distinction. It means even a stateless person on Indian soil cannot be arbitrarily deprived of life or liberty. They have basic human rights, even if they lack political rights. The state defines who belongs, but human rights define how human beings must be treated, regardless of their papers.
Let's shift from the people back to the land itself, sovereignty. We mentioned that conquest is illegal, so how does a country legitimately get more land? Or lose it?
Well, you have accretion, which is natural expansion like a river shifting and creating new land, and you have cession, which is transferring territory via treaty.
But cession isn't a simple signature. The Borobar Union case is the landmark here. I found this fascinating because the Prime Minister thought he could just sign a deal.
Right. In 1958, Prime Minister Nehru signed an agreement to transfer a small enclave, Borobar Union, to Pakistan to settle a border dispute. He thought it was an executive decision, but the Supreme Court stepped in and said no.
Better check on the executive.
They ruled that the Indian government cannot just cede territory by a simple agreement. You're effectively changing the definition of India. To do that, you need a constitutional amendment under Article 368. You have to go to Parliament and change the Constitution itself. It sets a very high bar for giving away land.
Now, talking about land brings us to the elephant in the room. Territorial integrity versus self-determination. On one hand, international law says borders are sacred. On the other, it says people have a right to choose their destiny. These two concepts seem to be in a cage match.
They are the central tension of modern geopolitics. But India has a very specific, carefully calibrated position on this. When India signed the UN Human Rights Covenants, it added a reservation, a formal legal caveat.
And this nuance is vital. How does India define self-determination?
India interprets the right to self-determination as applying to peoples under foreign or colonial domination. In India's view, self-determination was the tool for decolonization. It was the mechanism to kick out the British.
So once the British left, the job was done.
Exactly. Once the country became independent and democratic, the right to self-determination was effectively used up. It does not apply to parts of an independent sovereign state trying to secede.
So the argument is that in a democracy, if you have a grievance, you solve it through the ballot box or the court's internal remedies, not by breaking the map.
Correct. There is a counter-theory called remedial secession, which argues that if a group is being massacred, they have a right to leave. But India and many other states staunchly prioritize territorial integrity to prevent fragmentation.
Moving from the borders to the embassies inside the borders. Let's go back to my opening scenario, the diplomat and the crime scene. We hear about diplomatic immunity all the time. Is it really a get-out-of-jail-free card? Can they literally get away with murder?
Functionally, yes. Under the Vienna Convention of 1961, diplomatic agents enjoy personal inviolability. They cannot be arrested, detained, or prosecuted in the host country.
But why? It feels counterintuitive to justice. It feels unfair.
You have to look at the functional theory. The immunity isn't a perk for the individual. It's a protection for the state. If diplomats could be arrested on flimsy charges, imagine how easily a hostile country could paralyze an embassy. They'd just arrest the ambassador for jaywalking or tax evasion every time there was a political dispute.
So it protects the communication channel. But what stops a diplomat from going rogue? If they can't be prosecuted, what's the check on their power?
The nuclear option is persona non grata. The host country, India, in this case, can declare a diplomat unwelcome. We don't have to provide proof or a trial. We just say, you have 48 hours to leave, and they have to go.
And once they are back home, their own country can prosecute them, right?
They can, and sometimes they do. The immunity is only from the host country's laws, not their home country's laws.
And the immunity extends to their stuff, too, the diplomatic bag.
That's sacrosanct. It cannot be opened or detained. It's supposed to be for documents, but history is full of stories of it being used for smuggling drugs, weapons, or even people.
Yeah.
But the rule stands. You cannot touch the bag.
And you cannot touch the building, the inviolability of premises. This is why people rush to embassies for safety.
Which leads to the concept of asylum. We need to distinguish between two types here. There's territorial asylum, like when the Dalai Lama crossed into India in 1959. We granted him protection within our territory.
Versus diplomatic asylum, which is hiding inside an embassy like Julian Assange in the Ecuadorian embassy in London.
Correct. Interestingly, India generally does not recognize a legal right to diplomatic asylum. We follow the Havana Convention logic on this, which is that embassies shouldn't become hideouts for fugitives. If you commit a crime in Delhi and run into an embassy, India will demand you be handed over. We view territorial asylum as the legitimate path, not hiding in a building.
Okay, we've covered the land. Let's head out to sea. The source material calls the UNCLOS the UN Convention on the Law of the Sea, the Constitution for the Oceans.
It was a massive achievement in 1982. Before this, it was a Wild West. UNCLOS basically zoned the entire ocean.
So let's visualize the map. Standing on the coast of Mumbai, looking out at the Arabian Sea. The first 12 nautical miles. That's the territorial sea.
That is essentially Indian soil covered in water. We have absolute sovereignty there. Airspace, seabed, everything. If you're in those 12 miles, you are in India.
Then from 12 to 24 miles, you have the contiguous zone.
This is a buffer. We don't have full sovereignty, but we have policing rights. We can enforce customs, immigration, and sanitary laws. It prevents smugglers from hovering just outside the 12-mile line and sending small boats in.
And then the big one, the Exclusive Economic Zone, or EEZ. That goes out 200 nautical miles.
This is purely economic. We own the fish, the oil, the wind energy, but we don't own the water. Other countries have freedom of navigation. Their ships can sail through our EEZ, but they can't fish there.
And this freedom of navigation applies even closer to shore, right? Innocent passage.
Yes. Even in our territorial sea, foreign ships can pass through as long as they are innocent. That means no weapons testing, no spying, no fishing, and no pollution. They have to keep moving.
But disputes happen. The Enrico Lexi case, the Italian Marines incident, was a huge one for India.
That was a jurisdiction nightmare. 2 Italian Marines on an oil tanker shot 2 Indian fishermen. Italy said, It happened on an Italian ship in international waters, so it's our jurisdiction. India said the victims were Indian and it happened in our zone, so it's our jurisdiction.
And we actually went to the tribunal for this, ITLS.
We did, and while the outcome was mixed, the Marines were eventually tried in Italy, it established that India is willing to use international legal mechanisms like ITLS to resolve high-stakes conflicts, rather than just escalating militarily.
From the deep ocean, let's look up, way up, to the moon. I was surprised by how much legal tension there is in outer space right now. It feels like we are on the verge of a new gold rush.
We are. The foundation is the Moon Treaty of 1979 and the Outer Space Treaty. The core principle is that the moon is the common heritage of mankind.
Meaning you can't own it. No one can plant a flag and claim a crater as the 29th state of India.
Exactly. It cannot be militarized and it cannot be appropriated. India is a signatory to these treaties. Ideally, we view space as a global commons.
But reality is catching up. We now have the Artemis Accords, led by the U.S., and India recently signed on.
This creates a fascinating legal overlap. The Artemis Accords push for safety zones around lunar bases and explicitly talk about extracting resources. It's moving away from common heritage toward finders keepers.
So ISRO is in a tricky spot. On one hand, we support the UN model of space is for everyone. On the other, we don't want to be left behind while other nations start mining lunar water or helium-3.
It's a classic case of law struggling to keep up with technology. The Unispace conferences are trying to coordinate this, but the tension between sharing space and exploiting space is the defining legal battle of the next decade.
Speaking of global coordination problems, we have to touch on global health, the WHO. We saw during the pandemic that international health laws have some serious teeth, but also some serious gaps.
The World Health Organization has what we call normative power. They set the standards, what counts as a pandemic, what air quality targets should be, but they lack enforcement power.
Under the International Health Regulations of 2005, countries are supposed to report outbreaks immediately.
Yes, that is the obligation. But if a country refuses, if they hide the data, the WHO cannot send in inspectors without permission. They can't sanction the country. They rely entirely on cooperation. It's a system built on trust, which is dangerous when trust evaporates.
So we have rules for land, sea, space, and health. But what happens when a state breaks these rules? If a country commits an international tort, how do we hold them accountable?
This is the realm of state responsibility. If a state breaches a treaty, it must make reparations, usually restitution or compensation.
But attribution is tricky. If a mob attacks an embassy, is the state responsible?
Generally, a state is only responsible for its own organs, police, military, officials. However, there's a due diligence clause. If the police stood by and watched the mob burn the embassy without trying to stop it, the state is liable for a failure to protect.
And if we can't settle it diplomatically, we go to court, the International Court of Justice in The Hague. But here's the catch. You can't just drag a sovereign country to court. They have to agree to be sued.
This is the optional clause. States can declare that they accept the ICJ's jurisdiction. India has done this, but with a laundry list of reservations.
I saw that list. It's extensive. We won't accept jurisdiction for disputes involving national security, self-defense, or, interestingly, disputes with other Commonwealth members.
Which effectively excludes Pakistan, as they are a Commonwealth member. It's a strategic firewall. However, when the issue is specific, we do use the court. The Kulbhushan Jadhav case is the prime example.
That was a massive win for Indian diplomacy. Can you remind us of the details?
Certainly. Kulbhushan Jadhav was an Indian national arrested in Pakistan and sentenced to death. India didn't sue on the broad political conflict. We sued specifically on the violation of the Vienna Convention on Consular Relations. Pakistan had denied Jadhav consular access.
So we used the technical rule book to save a life.
We did. The ICJ rules in India's favor and ordered a stay on the execution. It proved that even with all the reservations, the system can legally compel a hostile neighbor to follow due process.
But there is one place where the system is designed not to work: the UN Security Council. We all know about the veto power of the P5, the permanent 5 members, but the notes mention a double veto. How does that work?
It's the ultimate shield. So the veto only applies to substantive matters, not procedural ones. If it's just a procedural vote, the P5 can't block it.
Okay, that seems fair.
But if the council starts arguing about whether a specific topic is substantive or procedural, that decision itself is considered substantive.
I see where this is going. It's a trap.
It is. A P5 member uses the first veto to classify the issue as substantive. Then, once it's substantive, they use the second veto to kill the resolution.
Heads I win, tails you lose.
Precisely. It's a relic of the 1945 power structure. India has been vocal about reforming this, arguing it paralyzes the UN, but for now, the double veto remains the law of the land.
We've covered a lot of ground here. We defined the state, protected its borders, gave its diplomats immunity, zoned its oceans, and looked at its lunar rights. But how does all of this international theory actually land in New Delhi?
This is the concept of dualism. India is a dualist state. This means that international law and domestic law are two separate bubbles.
So if the Prime Minister signs a treaty in Geneva, it doesn't automatically become law in Mumbai?
Correct. Parliament has to pass specific legislation to transform that treaty into Indian law. Until Parliament acts, the treaty is binding on the state internationally, but courts in India cannot enforce it against citizens. It keeps our sovereignty intact.
Before we close, I want to circle back to the very beginning. We asked why countries follow these rules if there is no global police force.
And the answer is the concept of opinio juris. It's the cement of the entire system. You see, a practice like not arresting diplomats could just be a habit or politeness. It only becomes customary international law when states believe it is legally obligatory.
Opinio juris necessitatis.
Exactly, an opinion of law or necessity. Without that psychological belief that we must follow the rules, the whole structure crumbles. It works because we believe it works.
Which leaves us with a final provocation for you. We've been discussing a world built by Grotius in the 1600s, a world of states, governments, borders. But we are now living in a world of SpaceX, of decentralized Bitcoin, of digital communities that ignore borders entirely.
That is the tension. The state-centric operating system is 400 years old.
Can this old rulebook handle a future where private companies colonize Mars and currencies have no nationality? Or is the international operating system due for a massive update?
That is the question the next generation of lawyers and citizens will have to answer.
Until then, keep questioning the rules. Thanks for diving in with us.